Hi, this is Advocate Lucinda, your empowerment lawyer. I want to provide information to a question that one of my subscribers asked, and it's regarding the 300-day continuing violation doctrine and how it relates to a workplace employment hostile environment claim, harassment. So you want to watch this. So let's recap the EEOC Title VII filing requirement as it relates to this 300-day continuing violation doctrine. To pursue an employment discrimination claim under Title VII, including a harassment case, hostile work environment, an employee must file their charge of discrimination within either 180 or 300 days of the unlawful employment practice, depending on which state the employee lives in. And just let me remind you of what those protected areas are under Title VII. Discrimination based on race, discrimination based on age, discrimination based on sex, color, religion, national origin, and disability. So the question is, what happens if the conduct that makes up the hostile work environment occurred outside the 180 or 300-day period? Can you use this conduct to make your hostile work environment claim? Let's see. Before we answer the question, let's hear what the Supreme Court said. Well, it said that a hostile work environment claim is comprised of a series of separate acts that collectively constitute one unlawful employment practice. And I have given you a case to read that will help you to fully grasp this theory. So let me speak a little more about the continuing violation meaning. If an employee files an EEOC charge while at least one act constituting the hostile work environment is still timely, then the whole time period of the hostile work environment can be considered for purposes of deciding liability. So the answer is yes. So I want to give you a scenario to help us to better understand how this continuing violation works. Now, let me also say that when you describe the harassment, the hostile work environment, you need to describe specifically those acts. You don't want to be general, you don't want to be conclusory, but you need to state what that specific act was. So when you state it, I ought to be able to envision it in my mind. Okay? So this plaintiff filed a sexual discrimination lawsuit. She claimed that she was discriminated based on her sex. She was harassed based on her sex. She alleged in her complaint that between 2003 and 2009, the person that she sued harassed her. Now, this was 6 years before she filed the lawsuit. She filed the lawsuit in 2009. Because of the harassment and the emotional distress that caused her, she took leave of absence between 2010 and 2011. Upon her return to work, the harassment started again. In 2011 to 2013, the harassment continued. 2013, the plaintiff filed her charge. So, is EEOC going to consider this as continuing violation? Check out this case. It is an excellent read regarding the continuing violation doctrine. In fact, the court found that the plaintiff could use the prior acts to make out her case. And I will be placing this case in the description page of the video. I hope this has helped you, and continue to ask questions, and I will make every effort to provide you with the law. Be empowered.